John?
Good morning, everyone.
Good morning. Where's coffee? Sure, get it going. I'll get it.
Well, let's talk first of all, as always, appreciate the opportunity to be here. I want to talk first of all about what we've got going on with the courts. It seems like we would like to try to put some of these issues away, and we can't get them put away. They keep coming up, unfortunately. First one is Calhoun County. You know the history. That case was won by the county at the district court level. It was won by the county at the Iowa Court of Appeals level. The railroad, as you would expect, then asked the Supreme Court to review the case further. The Supreme Court had, I don't remember the exact number, but it was between 30 and 40 cases for that month in which they were asked to provide further review. And they accepted 5 of them, and one of them was the ones they accepted was the Calhoun County railroad case. So we had hoped that with a strong district court decision and with a strong appeals court decision that the Supreme Court would not find basis on which to grant an appeal, but they did. And essentially what this means is this has become a very big deal now. Because you have the highest court in the state of Iowa has agreed to look at this case, and clearly it will establish precedent for everything that happens in the state of Iowa with respect to railroads and drainage districts. What has happened since then is that another railroad, Union Pacific, then filed papers with the Supreme Court saying they wanted to file a friend of the court brief in support of the original railroad. So now you have other railroads that are starting to see what's going on and have at least one who has come before the court and said, we want to file a friend of the court brief in support of Chicago Railroad on this case. What IDDA did at that point is to say, well, what's good for the goose is good for the gander. So we have filed a friend of the court brief. I called our president the day I saw that and said, Harlan, we need to get on board. We need to provide more than just funding for Calhoun County. We need to provide additional legal support because clearly the railroads are going to do that, and we have to give the county as much support as we can, and that means also filing a friend of the court brief. And he said, you're right, get it done. So I retained an attorney that day, and we retained the attorney, sort of cross-pollination here, we retained the attorney that is representing Monona County New Farmers Drainage Ditch against the action against DNR, because I had seen him in action in the courtroom, and he knows his way around a courtroom, knows his way through the appeals process, and also had some knowledge of the case, so I figured it was something that he could get up to speed on very quickly. So I contacted him, and he did agree to work on our behalf. So we will be filing a friend of the court brief also with respect to this case.
When is that due?
I haven't actually seen a due date on it yet. I don't know if the court has established a due date for the friend of the court briefs. I haven't seen one yet. But
the other question I had, they had to define a point to appeal on, and what was that?
I'd have to go back and look at the brief. They basically contend that the court erred in some of the interpretations that they did. The other thing that we are seeing now is that they are attempting to bring a new definition of culvert.
That's where I was headed.
Yes, there is some, and I don't understand all this, but there is some manual that is specifically for railroad construction, that lays out specs for railroad construction, and they're trying to cite this as a new authority on what constitutes a culvert to bring that into the case. So they're essentially trying to introduce new evidence into the case at this point. So we're looking at that. Both of the attorneys are looking at that. I asked Mr. Kramer, who is the attorney that represented Calhoun County initially and continues to represent them. I said, can we read anything into the fact that the Supreme Court agreed to hear this case? He goes, no, you can't. He said, there's people that spend lots of time trying to read tea leaves on what's going on in the Supreme Court. He says, you really can't do it. You can't make the assumption that they're accepting the appeal means they're going to overturn it. He said it could be something as simple as they recognize that this has potentially statewide importance, so they simply feel that they should weigh in on the issue. Obviously, we had hoped that we could put the issue to bed and say what's done is done. It is not done. So we are doing everything we can in terms of support of the county, and we will now have a brief representing all the drainage districts in the state. And I told the attorney, I said, if you look at what Union Pacific filed, they basically said, if the court finds against us, all of these costs are going to go to the railroad. And I wrote our attorney, I said, that's specifically our argument, because if we lose, all the costs are going to go to the landowners.
Well, haven't they already been with the railroad? The other thing that I find interesting about this whole deal, the culvert serves, they really serve the same purpose in that the culvert serves, drainage tile serves subsurface water, culverts surface water. Same purpose. One's underground, one's not. One does surface water, one does subsurface water. And how you can try and separate those, I don't follow. But
I think probably the railroad was a little surprised that they got the appeal. And I think that other railroads are seeing this now and said, oh, here's an opportunity, so they're trying to weigh in. As you would expect them to. That's the process. You would expect them to do the process. Don't blame them a bit for that. Whether they're going to have success entering new evidence in, I think, is another question. Because the Supreme Court said that we're not going to accept new evidence. We will accept friend of the court briefs, but we're not going to accept evidence that is in addition to what has already been entered into the record. The evidence is there, is the evidence we're going to view. So I think this other attempt to bring this new definition in is not going to work. I would be surprised if that works. So I still feel pretty good about the case. I just wish it had gone away.
And you can look at if you can look at this in two different ways. If they do not overturn this thing, that will put it to bed.
Yes.
Right. Whereas if they just let it go away, there would be another attempt down the line. So
yeah.
you can look at it in two different ways.
Yeah.
If they do rule in Calhoun County's favor, that's good for all of us, and it won't come back again, very likely.
I'm not an attorney, and of course I read the district court decision, I read the appeals court decision, and as I'm sitting there as a layperson with a lot of knowledge about the issue, but not an attorney's look at it, I'm going, gee, I just don't see a lot of room here it doesn't seem like there's a lot of gray area. The courts have both looked at the law, they both said that the law means the same thing, and I just didn't see a lot of basis on which, but, what to say. So that's the first thing. The other issue that we are continuing to be involved in is the New Farmers, Monona County case, which is the dispute with the DNR. And again, the history there was, this is administrative action, so It had to go through an administrative process before it could get into the courts. You had to go through an administrative law judge, where the trustees lost. You had to go through Environmental Protection Commission, Natural Resources Commission at the state level. That took place last summer. Trustees lost both those appeals. So now finally we are in a court. We are in district court in Monona County. And again, what happened here is Ivan Dressler, who is, the engineer who has been involved in the case from the start, came to me and he said, "Is there anything else IDDA can do? We're supporting the county, not the county, but we're supporting the trustees financially." Said, "Is there anything else you all can do to get involved in the case?" I said, "Well, we can file in front of the court." He said, "That'd be great." So we did that. So we hired Jim Kramer, who was the cow. So we've got the original attorney for New Farmers is filing in front of the court in the Calhoun case, and the original attorney for Calhoun County is filing in front of the court in the New Farmers case. Because they both have good knowledge of drainage issues, and they both have good knowledge of court procedure. So, New Farmers case, we have also filed in front of the court brief saying this case has special significance, and this really gets down to some of the immunity that we think exists for drainage districts and the actions the drainage districts can take that are provided in law. We think if the trustees lose this case, it could penetrate that immunity, and that's not a good thing. It is a very important case. So both of these cases are out there, and both of them I'd expect to, well, certainly the one before the Supreme Court I expect to see resolved this year. The one in district court could just be beginning because it took so long to get it to the court. So we'll have to see what happens after that. I guess the other potentially positive thing is that if DNR loses us at the district court level, which is my hope, we've got obviously a new director at DNR now, Director Designate, maybe with new people. Thanks, Chief. I don't know. Haven't seen enough that I can make that judgment. So that's the courts. Legislation-wise, for the first time since I've been director of IDDA, which was 2001, we actually had an interim committee on drainage this year, which met in December, and that committee looked at a number of different proposals and came out with 4 different proposals, none of them particularly sweeping, but all of them would be nice changes in the law. I guess the most important one for our consideration, and basically all these issues except for one revolved around this case out of Palo Alto County, where question of a lake that is empties into a drainage district, and whether that
Mike Winsey talked about that. Whether
that lake receives benefit, and the background of the case was Palo Alto County was going to do improvements. They came up with the assessment schedule, and the lake, there was a state-owned lake, and they determined that the level of benefit that the lake would receive from the improvements was $96,000, so they sent all the notices out. Notice went to the DNR, didn't hear anything back, proceeded through the process, got a bill, sent the bills out, and DNR says, "We don't know anything about this." Never got the notice, whatever. Dog ate my homework, I call it the dog ate my homework argument. So I went to the courts, and the district court agreed with DNR. And the first thing that the court said was that the county erred when it sent the notices out, when it sent the notice to the DNR, it just sent the notice to Department of Natural Resources, as well as State Office Building, Des Moines, Iowa 50309. The judge said that if the notice had gone to the director of the DNR, as opposed to just a flat mailing to the department, then there could have been certainty that it had been addressed to an individual in the department. So the court found fault in the notice that had been done.
In the delivery.
Yeah. So one piece of legislation we have simply provides in writing that for drainage district matters, if you have to notify a state agency, you send that notice to the head of the state agency. That is the requirement of the notice. That seems rather cut and dry. The other thing that was part of the district court decision, which was troubling, was basically the district court judge, in looking at the case, had to look at two prevailing points of view about the benefit that the drainage district provided to the lake. And one point of view was provided by Don Etler, who had done the engineering, who said, clearly the lake benefits, and here's the basis upon which we put these calculations together. The state's expert witness, which they called on their behalf, was Jack Greason, who is a state employee and well-versed in water quality issues, and he testified that the lake receives no benefit. So what this legislation would do is to specify in law that for drainage district matters, state-owned lakes do receive benefit from drainage projects. So that we don't have district court decisions sitting out there saying that that's not the case. Because clearly we have lots of potential situations and upcoming, and we have potential and situations that are existing right now where you've got drainage projects that are going to involve state-owned land or are going to involve state-owned lakes, and we don't want to establish a precedent and have a precedent sit there in the books and say the state is not responsible for paying these assessments, because that is not the case. So we're clearly trying to put language in the law that specifies that there is a benefit, and it's calculated as any other benefit would be to a landowner. That should come out of committee on the Senate side tomorrow.
How do they feel? How do you feel about the chances of that going on?
Right now, pretty good, but it's early. We haven't really seen any opposition surface, but it could happen. I mean, we're up in full committee tomorrow. We'll see if anybody comes out of the woodwork. And, the other part of it is just time. Everybody wants to get bills passed, and, there's only so much time. So how do you get your bill to the head of the line? That's always the difficult part as a lobbyist. I had some fear that the AG's office would come out and raise questions about it, which they potentially could. I had some fear the DNR might come out and raise objections to it, which they potentially could. But so far that hasn't happened.
The benefit that from the lake mirrors other reclassifications we've done is that it provides an outlet for the lake.
Yes.
And whenever we reclassify it, oftentimes new acres are brought into the drainage district because we're providing an outlet, if nothing else. And that's
what was the basis of their argument? I mean, if you're providing an outlet, you're providing the outlet. How could they say they did not receive any benefit from it?
Well, they probably would say the water always got out of the lake. Even if there was, sometimes creeks are improved.
Water will take its natural course. Lakes will rise. Lakes will fall. There is no benefit.
That's
so close up the ditch.
That's been discussed. That has been discussed. Close it up and we'll see without benefit. Yeah.
Well, it's, like landowners have challenged some of our engineers' reclassifications. Have gone for 100 years. We haven't been in this watershed, and now all of a sudden, not watershed, but the drainage district.
The other thing to come out of the process is, the issue that drove this originally was this $96,000 assessment from Palo Alto County that the state has yet to pay. That is a responsibility of the state executive council. It's not DNR's responsibility. Those bills go before the state executive council and they're decided by the state executive council.
Oh, I didn't know that.
Well, see, I originally didn't know that either. I made the assumption that the reason the DNR was making noise about it was DNR's budget. It was never DNR's budget. Never DNR's budget. It comes out of the state executive council. Well, Secretary Northey, in support of the drainage district, was trying to get the issue moved on to the agenda of the executive council. And the representative of the Attorney General's office wouldn't let him do that. Saying the case has been litigated, we're not going to let the executive council take it up. Well, what we're doing now is taking another run at getting this issue back on the agenda of the executive council. And what is going to happen is all 10 members of the interim committee, so you've got members of both parties from both the House and the Senate that are going to sign a letter. And Jack Hibby has promised me he's going to hand carry that letter around to the members of the executive council. And if we can get it on the agenda, we'll get it paid. I know, I don't have any doubt about that. If we can get the darn thing on the agenda, we think we can get the votes on the executive council to get the darn thing paid. It's just, we've got to get past the AG's office and get the thing onto the agenda. So that's
bipartisan support.
the way it's going to be.
Maybe at the governor's office, we can't lose. He spoke to that when we were down in Des Moines 2 weeks ago.
Yeah.
Jack, that his good friends from. So that sounds encouraging.
Yeah.
That really is interesting.
That whole case has been, it's just odd. It is just an odd case. I mean, I look at it as an outsider, and nothing about it makes sense. This should have been a routine matter. I mean, and all the twists and turns this has taken, it is one of the most puzzling things I've seen. And to say, first of all, that the state would deny that it got the claim, and a judge would uphold them, and then, okay, well, let's get it to the executive council, and we couldn't get it to the executive council. I mean, it's just like, this shouldn't be this hard. This should be a routine matter.
Well, and we have, in our process, you go through all that notifying and the responsibilities we have with notifying landowners,
Yeah.
and that you do that, and you do your due diligence, and people might not want to pay it, but they do know that they are responsible.
And this was a case where, the county did what, the drainage attorney who was advising the county prepared the notices, and did the notices in exactly the same way he had hundreds of times in the past. Never been an issue. So those are what we're working on, and it's courts and legislature, and that's keeping us busy.
One thing that we had a discussion locally in our 4-county meeting, there is a county or two FSA office, I think it's FSA, not NRCS, but had a situation where they were, our drainage attorney, Mr. Hudson, delivered the message that a couple of the FSA officers were indicating that if we did a project in the nesting season, that they were going to make contract holders pay back their buffer strip CRP payment. Dean and I both farm, and I guess I kind of lit into the attorney saying that's just absolutely foolishness, in that we have a limited amount of time to do these projects anyway. They're on a 35 to 40 year rotation, so you would have one disturbance in possibly 4 years, and if they start enforcing that or trying to do that, most of us are not going to keep our buffer strips the next time that contract comes up, and that would be so unfortunate, because they are a very, very good tool to keep both residue and contamination out of our drainage ditches. I couldn't believe that they were bringing up discussion.
Well, I wish I had good news for you, but I don't. We've had discussion about trying to get FSA moved off of this apparently new interpretation of the law. I had a meeting with Farm Bureau in January on a number of issues, this being one of them. And what Farm Bureau did at that point was write Washington, D.C. On behalf of Iowa Farm Bureau, which has more clout than IDEA, and say, here's the deal, what is going on, basically. And we received a reply back within the past 2 weeks, which is basically the head of this, whoever is in charge of this process in Washington, D.C. is basically saying that FSA is now taking a position, is going to enforce the position, that they're not going to permit disturbance during that season.
So we need to do this through our local representatives and senators then, because this is just ridiculous. And if they enforce this, most of us are going to discontinue our buffer strips. We're going to plow it right up to the edge, and it's just foolishness.
Yep, I agree.
We talked to Congressman King's aide, Wayne Prince, a month ago about this. But it's a federal call.
Yes.
Because I thought it was, I guess he is a federal employee, the head of the FSA in Iowa, and it's his change of interpretation before the local, like the Sac County FSA committee could grant an exception, and that's the way we've been operating. But this,
what we're going to do now, we're going to do two things. We're going to write back to this gentleman and say, okay, you said this is your policy. On what do you base that policy? Show us the rule. Show us the law. Because what we have found over the years is that many times federal agencies have these policies, but they haven't gone through an official rulemaking process, and stuff that has basically just been sort of made up as they go along. So we're going to say, okay, you are telling us this is your interpretation. Tell us what that interpretation is based on. Show us the regulation or show us the law. So that's the first thing we're going to do. Secondly, we'll work with Farm Bureau to say, well, if we need a change in law, how do we do this? Obviously, we've got a Farm bill coming up. That would be the logical place to do it. So what do we need to do to get the appropriate language in place to get this switched around? So that's sort of the tack we're taking.
And I guess that's one of the, I think we think that's a priority, just because I've described what the net effect is going to be.
I know, that will be the effect, there's no doubt.
Yeah.
There's no doubt.
Yeah, a lot of contracts are starting to come out.
Yeah.
Some of our early contracts, 10-year contracts, are coming out, and the timing's bad because crop prices are high.
Yeah.
Looked at, if you re-sign it up at a better rental rate, and then if you've got a ditch that's reaching its maturity, it's reach clean out, we're just going to see a lot of people say, like Rick's saying, it's too expensive. I brought it to the attention of some DNR people that we've been meeting with on a lake restoration project. There's 5 or 6 different divisions of the DNR at these meetings. Well, drainage isn't good for most of them.
That's right.
Remember at that hearing we had and the fellow from Grinnell, he was talking about drainage just being portrayed as contributing to a lot of the stormwater events, like the Cedar River. And there's just,
and that's
we don't get a lot of support from the Department of Natural Resources. The Topeka Shiner, that the supervisor should hear better tell the stories. Supervisor, we had an open, governor was there, Lieutenant Governor, and Senator McKinley and Kibbe, and the supervisor from Carroll County got up on the mic and said that they'd had a bridge project stalled in Carroll County for a year or two.
Yeah, not a while.
There's some little species of fish that's, and the supervisor pointed out that if the Department of Natural Resources is really worried about those fish in that area, they they'd commercially trap all the raccoons. Because that would have a
Sure,
more
much
net,
better.
net effect.
Yeah.
Neil Bach, he has a company that sells traps or makes traps. But he got a standing ovation.
Yeah.
Or not, he got a lot of sympathy.
With what Dean had been talking about as far as the water vents, that's not well thought through either, because if you have a system that 365 days a year continues to drain property, you have a much bigger holding pool than in a big event, rather than if it's sitting there full, it's all going to run off. Whereas if it's done over time, your capacity is much larger,
Yeah.
and so they don't think that through either.
Yeah.
I mean,
Well, there's varying opinions out there about drainage and some of these flooding issues, and there's not really any definitive answers right now. I mean, what I say is that we need a lot of study to determine exactly what role, if any, drainage plays in flooding. I'm sure that there is a role, but I said what I do know, and what is undisputed, is two things. When you drain land, it changes the soil profile, and the soil holds water better. That's the first thing I know. The second thing is, if you took all that water that is going through drain tile in a flooding event, and you put that water across the surface of the land, as opposed to through the drain tile, the damage would be much worse than it is going into a controlled drainage situation. I mean, those are the two things I know. Other than that, there are things that can be questioned, and that's what we need research to find out.
You need to point out that all the thousands of miles of terraces, the tile are an integral part of the engineering of terraces. And terraces, if you have a big rain event, terraces hold water back. Nobody's going to dispute that. But you have to have a tile system as part of the engineering to maintain the integrity of the terraces.
Well, I talked to a group of engineers in December, and I said, it was in January, and I said, there's a lot of people out, not a lot, but some people that think the drainage causes flooding. And I said, drainage causes flooding. You know what causes flooding? Number one, it's too much rain. Secondly, if you're concerned about flooding issues, don't build in the floodplain. And that's a lot of the problem we have now. We have a lot of construction that is just taking place in the floodplain. So you get an excessive rain event, water, gee, guess what happens? Surprise, surprise.
thank you, John.
Thank you very much. Appreciate it.
Got a question from
I have a question back.
What are the case numbers for each of these things?
Pardon me?
Do you know what the case numbers are for each of these
No, I
lawsuits?
do not.
What are they filed in the counties you mentioned, Calhoun and Winona?
Yes.
What do you know the?
You know,
Is there a way to reference
drainage
these things when I ask for them?
they're not supervised.
They have that option.
Well, if you go to the Supreme Court website,
I said at the drainage conference in Portland.
the Calhoun one should be fairly easy to find, because it'll be listed as a case that they've taken up on appeal. To get the case number in the other case, I think you would probably just call the clerk of court in Winona County,
So they have a
Okay.
choice.
or call the drainage clerk over there, Bonnie Kendall, who works in the auditor's office. She could give you that information.
Okay.
All right?
Thank you.
Thank you, John.
Thanks.
Thank you very much.